Hi, I'm Andrew Struve. I'm a shareholder at Buckhalter APC in California. Thank you for your time today. Here to talk to you about how insurance can assist your clients and your practice. This is a broad subject. We won't be able to accomplish everything that one could accomplish within the space of an hour. What I'm hoping to do is to convey some parameters of the broad aspects that need to be kept in mind. And this will vary on a state-to-state basis. Under the federal McCarran-Ferguson Act, insurance is regulated on a state-by-state level. It is not regulated at the federal level with certain exceptions, like under ERISA. So each state will vary. And I am only a California lawyer. California is a very policyholder-friendly state, and but it also is a very big state. And so I will give you a general gist of the law. And what I will do when it seems appropriate is contrast my home state of California with one of the more insurer-friendly states like New York or Connecticut. To the extent that I know their law. But it's very important not to just take my word for it, but to just understand the broader concepts. And then to focus on your own individual state's law. Because trust me, they do vary. You can do things in New York and in Connecticut and in Texas and other places that you cannot do in California. And insurers know that. And so when you have a client come in that has a potentially covered claim, one of the first things you have to do as counsel, outside counsel, even inside counsel, frankly, is to scoop up the potentially applicable insurance policies and read them very, very carefully. Because quite a few of them will have state-by-state riders that vary the terms of the general policy based on the individual state in which it was issued. So let's talk about the state in which the policy was issued. As a general rule, one would think the policy is issued in your client's state of incorporation. That's not necessarily right. Where the policy was mailed, and they have to mail them, is often determinative of which state's laws govern. And so one wishes to keep that in mind. And if you're inside counsel, and say you're incorporated in Delaware, there's potentially an argument about where your principal place of business might be, you might consider where you have your policy mailed. Mailing it to a policyholder-friendly state would not be the worst idea. Actually, it would be a pretty good idea. So let me step back for a second. When you have a potential loss, the first thing that I would recommend doing, whether you're outside counsel or in-house counsel, is to gather up all potentially applicable policies and to decide whether to submit a claim and under which policies. There's an old adage, tender early and often. That's not necessarily right, because a lot of policies experience rate, meaning the premium increases when a claim is made, regardless of whether the claim is honored. And stepping back once again, I have had it's actually been a gift of representing both insureds in bad faith cases and insurance companies in bad faith cases. So I've gotten an opportunity to peek behind both sides of the curtain. So I have a little understanding, perhaps more than a little, of how the policyholders regard their needs and how the insurers regard their obligations. And so what I'll attempt to do is to take a middle bridge with you today and share with you my thoughts on the interplay between the two. So, with that said, the first thing that I would say is to determine what kind of policy you have. And they're not that easy sometimes to determine if you're not an insurance professional. Do you have a time on the loss policy? Meaning if you had coverage 5 years ago and you get a 5-year-old claim, does the policy cover it? Or do you have a claims made and reported policy? It's very different. And I'll get to that in one moment. Claims made and reported policy means a claim has to be made against the insured and has to be reported to the insurer, both within the policy period. If that doesn't happen, it is a common basis for denial. I had a lovely situation for a client some years ago when they got hit with a $100 million lawsuit. And the lawsuit was filed in late December of year X. And then the insured switched carriers in year X plus 1 in January. Each carrier denied on the basis of claims made and reported. They said, well, the claim was made in year X. It was reported in year X1. And so both insurers were perfectly happy denying the claim. We made some newsworthy law where the court, in a decision that was very helpful to the client, not particularly helpful to the insurers, decided that each carrier had time on the risk. So basically we had 2 policies in force. So this is a preliminary thing, right? When we turn to our topic of how can insurance assist your client, you have to figure out what kind of insurance you have, and then what the tender dates are, and what the circumstances are for making a claim. It's very key. There are a number of organizations that write standard form policies, but to the average lawyer, frankly, it's 100 pages of gobbledygook, right? And it takes a while to sort through. The trouble is, insurance lawyers can sort that gobbledygook pretty quickly. And from the insurance company perspective, you will not get a break. So the trick is to keep in mind in the beginning, has a claim been asserted? And what type of policy do you have? So let's talk about, has a claim been asserted? Well, that's going to be determined by the language of what is a claim in your policy. Sometimes it might be a threat of a claim for liability. Other times, a lawsuit obviously is obvious. That's certainly a claim. But the claim definition triggers your reporting obligation. And If you don't report within the legal standards of the policy, then you have arguably no coverage. It's like a private statute of limitations. So it's very important, if you have a threat, not even a lawsuit, but a threat, to review your coverage and see if you have what is defined by policy as a claim. Insurers are very happy to enforce the notice and reporting provisions of these policies. And when we think about standard contract law, in my state, 3 years on written contract. But that can be modified by written agreement. And in a lot of insurance policies, it'll be modified to as little as 6 months. And that poses a serious consideration for you as either inside or outside counsel. And I can't suggest enough how important it is at the beginning of what you think might be a claim to explore coverage. Your company or your client has paid for it. It's a contract of indemnity. It shifts the risk to somebody else who is better able to bear the risk. But if you blow through the terms of the contract, then coverage denial very well may happen. And that poses, frankly, for outside counsel, significant malpractice risk. For inside counsel, significant embarrassment or worse. So one of the first things you should think about when you're confronted with what you think might even be a claim is to consider the availability of coverage and to parse the terms of the policy carefully. And in a lot of circumstances, if you're on the receiving end of one of these, I think that insurance company counsel that have been practicing for a long time don't need my thoughts on this issue. But for insureds, it is a very, very significant consideration at inception. That turns me to the subject of whatever the policy says in terms of when a claim needs to be submitted. There are potential tolling circumstances. In a lot of circumstances, as an insured, the insurer will not send you a nice note saying your notice period has potentially been tolled. I will give you an example. In California, when the COVID state of emergency came up, the governor of California issued an order to our Department of Insurance telling them to toll the notice provisions on every policy issued to a Californian. Well, that state of emergency, as of this taping, still is in existence. So a 6-month notice provision that might have expired 2.5 years ago has not expired. But don't count on your insurer to point that out to you. You have to be aware of it and you have to research it. Your local Department of Insurance or whatever it's called in your home state will have things online about this. So I would urge you not to miss that potential. So that's my brief peroration starting in. My slide deck has a bunch of slides about various insurance companies and their open hands, and then there are a lot of old jokes about how the hands curl up when you have a claim. I'm not going to worry about any of that. I want to be appealing to the broader market, so I'm not just speaking from a plaintiff's side here. The basic forms of coverage that you should be aware of, you have CGL, Commercial General Liability. You have Employment Practices Liability Insurance, which is called EPLI. You have Director and Officer Liability, D&O. You have Pollution Legal Liability, PLL. You have Title Insurance. You have Representation and Warranty Coverage, R&W. You have Property Insurance, and that applies to businesses, not just your house. You have long-term disability that applies to your employees, applies to your officers, applies to anybody covered under the policy. And then you have cyber insurance, which is increasingly important. So when you have a claim that you're made aware of, there is often an overlap between these coverages. It may be a blended claim. So if you look at what the demand letter is, you look at what the complaint is, you look at what the cause of action are, you look at what the allegations are, you look at what the alleged facts are, you may find a basis for coverage under multiple policies. It may not be as obvious as it first facially looks. So that goes back to my earlier suggestion that it's worth grabbing every policy you have and taking a look at the potential for coverage and deciding whether to tender under it. It's very, hypothetical, right? Officer of the company leaves protected health information out in public, and the protected health information is potentially breached, and somebody does something online to affect the patients, right? Well, that's a blended claim. That blends under your D&O insurance, your director and officer insurance, and it also blends under your cyber insurance. So in that sort of situation, if the claim amount were serious enough, one would consider tendering to both, because both carriers would have what we call time on the risk. So it's not always, I can do more. Property insurance can blend with title insurance, can blend with pollution legal liability. It depends on the allegations. So there may be multiple carriers with multiple time on the risk. So I offer that for your consideration. We can turn to the concept of first party versus third party liability. First party liability is where the named insured suffers a direct loss of some property and looks to the carrier to be made whole. And by the way, loss of property can be a claim of damages. That's inchoate loss of property, right? Third party, the policyholder is accused by a third party of some kind of liability and looks to the carrier to be made whole. Third party liability is harder to achieve. In California, it's extremely hard to achieve. But again, like I said, under the McCarran-Ferguson Act, this will vary from state to state. You want to check. You want to check, because in some states, so first party, the insured, the putative defendant or the actual defendant, is suffering the loss, is suffering the liability. In third party, the allegedly injured person or entity has suffered the loss and is suing or claiming against your insurer. So you need to figure out in those circumstances what the law of your state is. Now, there are hybrid policies. Hybrid policies are obtainable. Hybrid policies cover both. The law governing that varies from state to state. So in a hybrid policy, for example, if my housekeeper falls down the stairs, she can sue me, and then I can make a claim against my homeowner's insurer. In a hybrid policy, she could sue the insurer and make a claim directly against them and against me, no doubt. So that's another question of looking at the policy and figuring out exactly what you purchased. I want to go back to the concept of occurrence versus claims-made policies because it is such a key distinction. Occurrence-related will stick with the policy in general, even after its expiration. In a claims-made and reported policy, it has to be made and reported within the policy term, or you have no coverage. There are also differences between when the claim has to be filed and the applicable notice requirements. And by the way, these are substantive requirements. They're not just clerical, they're not just paper pushing. They get vigorously enforced. And I go out of my way on these classes that I do not to name specific entities, and so I shan't. But some of these are very strictly enforced, lovingly enforced. And the failure to identify the correct policies and policy periods and satisfy notice requirements can result in a loss of coverage. So something that you, your firm, your client paid for could be worthless, even though there was coverage. I can tell you from experience, not personal experience, but from experience, not personal experience, thank God, but professional experience, that these notice requirements are very, very serious, and they have to be observed. And if they're not observed and you make a claim, the claim is denied, you litigate against the insurer, the insurer's decision is upheld, who do you think the client is going to look to next? That would be you. And there are a number of cases from around the nation that if the outside counsel fails to observe, fails to notice, no pun intended, a notice requirement, that can be considered malpractice. And the value of the loss is what the insurer would have maximally paid. So one of the first things to do upon getting any potential claim is to pay attention to the policies. So occurrence policies, general liability, auto liability, umbrella. By the way, hang a footnote on that, umbrella. It always makes sense to see if your company or you or your client has umbrella coverage. Sometimes people forget they have it. Umbrella coverage is reasonably inexpensive compared to the underlying policy, but it can be life-saving in the event of a potentially massive claim. And so the trick is to ask early and often if there is an umbrella policy or any other policies in existence. Occurrence policies cover claims for injury or damages during the policy period. We cover that. Coverage is triggered by filing a suit against the insured. It's also probably triggered by filing a pre-suit claim. The timing of the suit is essentially irrelevant to coverage, but it's not irrelevant at all to notice. Continuing injury or damage can trigger coverage under multiple policies. So, for example, on a pollution claim, right? If the pollution has been going on for 10 years, allegedly, then, and say you have a new pollution policy every year for 10 years, you may have coverage under all 10 of them because it's under the continuing harms doctrine. And so you need to look not only at what you currently have, but what you had in the past. The notice requirements, you know, the general rule is that even if you blow through the notice requirements, don't throw up your hands and abandon all hope. Because the general rule is that even in the absence of timely notice, the insurer has to show prejudice by the lack of notice. I would not rely on that personally. It's kind of like a throw to the end zone. I'd prefer to just give timely notice. But if you find yourself in a situation where timely notice was not given, but you can't identify any prejudice, then what the heck? You can take a shot at it if you're in a jurisdiction with the prejudice rule. So I offer that to you for your consideration. When I spoke earlier about the notice requirements, you have to strictly follow what the policy requires. Not just the timing of the notice, but where do you send the notice? To whom do you send it? To what address? By what method of delivery? Because if an insurance company wants to deny coverage, they will sometimes glom onto those kind of things. So I think that's very much important to focus on. So for people both in-house and outside counsel, you need to make sure at the beginning that the client knows what policies it has and has copies of them. You need to determine, I wouldn't rely on the client for this, you need to determine when does the policy expire. Don't get tunnel vision versus the applicable policy periods. Prioritize claims made notice. Follow the notice rules. You will find in some policies a 12:01 a.m. expiration date for notice. They're not kidding. They'll rely on it. All right, let's turn to the duty to defend. So the duty of an insurer to defend under a policy is broad. It can include groundless claims, false claims, fraudulent claims, allegations of intentional torts, allegations of willful act, or allegations of criminal conduct. The insurer must defend a suit which potentially seeks damages under the terms of the policy. Potentially. So let's talk about that. Let's say that I get sued for running over your cat, God forbid. And the complaint says, count 1, I deliberately ran over your cat. Count 2, I negligently ran over your cat. Well, a duty to defend is triggered there because the complaint includes an allegation of negligence. Now, if the jury determines that I deliberately ran over your cat, I'm out of luck, and I got to pay the insurer back for the cost of defense. But if there's a negligence allegation inside, then there's a duty to defend. There is a case called Montrose in California that says the defense is excused only where the third-party complaint can by no conceivable theory raise a single issue which would bring it within policy coverage. So let's focus on that. Let's go back to the cat. There's an allegation that I deliberately ran over 12 cats and negligently hit the 13th. Coverage, right? Under a reservation of rights, but coverage. So the insurer has a duty to defend. They make the determination. They have to do it in good faith. They have to construe the policy in the most favorable way to the insured. That's an obligation. If anything is ambiguous in the policy, it needs to be construed against the insurer. So, insurer may have a duty to defend based on either the allegations in a third-party complaint, the allegations in a first-party complaint, any facts known to the insurer from any source. The only thing is no potential for coverage exists in speculative pleadings. Well, that's fair. The duty to defend arises when the insured tenders defense of a suit. The duty to defend does not end until either the underlying lawsuit is concluded, the facts show there is no potential for coverage, or the policy limits are exhausted. We should talk about that for a second. Many policies have what we call burning limits. So you may have a $5 million policy, but the defense costs erode the $5 million. So if you have a $5 million policy and your defense costs are $2 million, then your coverage at time of trial is $3 million. It's called a burning limits policy. So one wishes to be aware of whether they're facing a burning limits policy or not. We can talk about next independent counsel. There are, most insurance companies have their own various favorite outside law firms. A lot of them charge very little. I had a client who was faced with a huge lawsuit where they were proposing counsel who charged $230 an hour. It's not really good when you've got $100 million at stake. If there's a conflict of interest between the insured and the insurer, such as when the insurer has adopted the defense under a reservation of rights, most states will allow the insured to select independent counsel, which will be paid for at a reasonable rate by the insurance company. Insurance companies' views on what is a reasonable rate are perhaps lower than what my rate is, but they're required to pay market rates. California is called CUMAS counsel. So the duty to indemnify is triggered. Now, I'm not talking defense. I'm talking indemnity against liability. The duty to indemnify is triggered when liability is established. When liability is established by a verdict of the court or by a settlement in which the insurer participates. In the event you're considering settling an action of any significance, it's always a good idea to have counsel from the insurance company present so they can consent to a settlement, so they don't later claim it was excessive. So I would urge that. I would also urge, in a perfect world, it's really good as an insured or as outside counsel for an insured to work cooperatively with the insurance company to the extent they're willing to do it. It makes life a lot easier. I've had situations that were quite hostile, and I've had situations that were extremely cooperative. And I would highly recommend the latter if you believe the company is honoring its obligations to you as a client or to your client. Turning to the obligation to settle, this is an important point. An insurer is not required to take every settlement demand. An insurer can decline a plaintiff's demand. In California, as in a number of states, if an insurer declines a plaintiff's reasonable demand, underline the word reasonable, and then there's ultimately a verdict that is in excess of policy limits, we say the lid is lifted off the policy. The insurer pays the verdict. So if I have a $10 million policy, plaintiff offers to settle before trial for $8 million, insurer declines, verdict comes in at 45, insurer pays the 45 million. That's just how it works. I reiterate that it's very important to have the insurer working with you in the concept of resolving a potential claim. For those of you with potentially big losses or potentially unusual risks, I can tell you that most policy forms in the United States are standard. They're the same form. I'm not going to recite the two outfits that write them. But I would reiterate that in the case of unusual risks, there are firms that will write what we call manuscript policies. In other words, they actually draft them. Example, if you are a member of royalty who has a stable of racehorses and transports them by 747 to various polo tournaments, you can't exactly go to a standard insurer and get that. But a manuscript policy issue will write you a policy. They just do the underwriting. These are people with much better math skills than I have. The other thing that's interesting is post-loss policies. You can actually insure against a loss that's already occurred. Reasonably little known fact. So if you have a pollution spill, let's say, well, the spill's already occurred, and you're facing liability of XXX million, you can actually buy a policy to indemnify you against being held liable for that. It's going to be pricey. But it's an idea to explore if you find yourself in that kind of situation. It also is very helpful if you find yourself or your client, hopefully your client, with a gap between their primary coverage and their umbrella coverage. I've seen situations where there's been a $100 million gap. Well, I can buy coverage to fill in that $100 million. What will it cost? I don't know, depends on the loss. Probably about 25 million, depending on the loss. But you can fill in the gap. Why is that important? It's important to the client because there are some circumstances where, say you have a 10% chance of a $400 million class action verdict. Okay, so simple math tells you, simple underwriting would tell you, the cost to insure against a 10% chance of a $400 million verdict should be $40 million, right? Plus profit for the insurer. They'll figure out what that is. I'm sure they're good at that. The difference is for the client, that can be life-changing. If a CEO takes a 400M loss, that can result in termination. If a CEO takes a $40 million hit and pays it out over 5 years, that results in a footnote in the SEC filings. So it's advice that I've given in the past, and I have to say it's been followed. So anyway, so let's talk about the burdens of proof. The insured bears the burden of proving coverage. The insurer then bears the burden of proving exclusion or other limitation to bar or limit coverage. So first you have to, as the insurance counsel, submit a proof of claim that establishes coverage. And then the burden shifts to the insurer to demonstrate that no coverage exists. Additional assurance under commercial general liability policies, client is entitled to coverage under a CGL policy held by a third party who provided goods to or performed services for the client. That's absolutely right. If you're in a big box store and a supplier has palleted goods and they have not properly packed the pallet and it falls on you, the big box store is entitled to coverage under the CGL policy of the supplier. So it's a very good contractual risk transfer device. It's a right created contractually. The protection comes from the CGL's, the third party CGL's insurer. It's always good to be an additional insured on such policies. And that's always something to request on the certificate. Employment practice coverage, EPL. So, types of claims that are covered: wrongful termination, actual or constructive; wrongful demotion, failure to promote; wrongful refusal to employ; negligent hiring or supervision; discrimination; harassment; coercion; retaliation; libel, slander, invasion of privacy, abuse. Okay? Those are typically covered under an EPL policy. What isn't covered are wage and hour claims, mostly, although you might be able to get an endorsement to that effect. Again, read your policy. Criminal, fraudulent, or malicious acts, willful or intentionally harmful acts, workers' compensation, your client will have a separate policy for that anyway. Disability benefits, same thing. The client either offers it or they don't. Violations of statutory employee protection laws, certain contract claims, certain other tort claims. It kind of goes back to review the policy. Some giveth more than they taketh. And be sure, and this applies to all policies, be sure to read the riders. I have seen 100+ pages of state-specific riders. Read them, okay? Don't necessarily assume that just because you live in state X, that the state Y rider doesn't also cover you. So if you're kind of unfamiliar with this area, it's probably a good idea to bring in an insurance coverage practitioner, just to give it a look-see. I won't bang on my malpractice drum again, but just to give it a look-see, because there's often lurking coverage that may not be immediately apparent. So on the EPL, Employment Practices Liability again, it's almost always written on a claims-made basis. It encompasses both defense and indemnity. The covered loss almost always includes defense costs, making it what I call a burning limits policy. And deductibles and self-retentions are the obligation of the employer, which is the case on most of these policies generally, by the way. There will be a self-retention, and a typical one for a large enough business is maybe $250,000. You want to be aware of the self-retention. The other thing, going back, I really wish I'd said this earlier, but I'll say it now. The other thing, going back to the notice issue, is if your company or your client gets sued and you wait to tender the claim, say you stall out for 3 months, 4 months, 5 months, 6 months, you take advantage of an exception, that kind of thing. It is very hard to get paid for your attorney's fees between the time of the claim and the time of notice. I have seen people get bitten by that dog on more than one occasion, and the courts usually uphold that principle. So that's why you want to assess coverage early and tender if you believe it's appropriate to tender. Areas of negotiation on these employment practice liability claims. The first thing I would look at after the insurance coverage is the existence of an arbitration agreement. That can be extremely beneficial in terms of saving cost. And often employers have them. And I wish I could tell you how many times I've seen defense counsel totally ignore the existence of an arbitration provision, which makes me want to rip my remaining hair out. Choice of law is another issue. Choice of law will also relate to your relationship with your insurance carrier. So, say your insurance policy says it was issued in the state of New York, and if I were writing one, that's sure what I would do. But it's mailed to California. Okay. Say that you get into a tiff with your insurance carrier about some aspect of coverage, and say the tiff gets a little serious. Well, then what can often happen is it's a race to court, and the insurance company may gleefully file a declaratory relief cause of action in the Southern District of New York or wherever they wish to, and try to take you out of California law. You, of course, would file a competing action in California. And then there's various procedural rules as to how that would be addressed. I've been in that situation and won a couple times, actually every time. But you have to be careful of first to file if you're in a dispute with your insurer. So you have to be mindful. If you find yourself thinking it's getting close to that, you may want to grab jurisdiction in a place that you like. D&O coverage, directors and officers. Directors and officers are targets of opportunity for plaintiffs' lawyers. They get sued for a lot of reasons relating to their capacities. Breach, and I'm not even going to cite the recent news that comes up every few weeks. Breach of fiduciary duty resulting in financial losses or bankruptcy, misrepresentation of company assets, misuse of company funds, misrepresentation on board calls to investors. Ooh, that's a bad one. Fraud, fraud is not good. Failure to comply with workplace laws, theft of intellectual property, and lack of corporate governance. So what I would suggest is even if you don't have an active claim, D&O coverage really protects the people who pay you. Trouble is, many of the wrongful acts that trigger the policy under D&O coverage may also trigger application of an exclusion. It's like the old saying, what one hand giveth, the other one taketh away. And this leads to the very broad definition, again, of a claim and strict notice requirements that goes back to coverage disputes. And then some companies combine their D&O coverage with their employment practices liability insurance. So the two may be lurking in the same policy. The relevant terms under D&O coverage: what is a wrongful act? What is a loss? What is a claim? And what is a notice of circumstances? Those are commonly used policy terms that you'll want to focus on when you're considering coverage. D&O coverage typically carries a duty to reimburse the defense costs, not a duty to defend. That actually may help you or your client, your company or your client, because you get to select counsel. And again, it's a self-depleting policy, a burning limits policy. So you have to be judgmental in how you spend that money. But you have a right to select counsel. Some policies have panel counsel requirements. I will leave it to your sound judgment as to whether you wish to use panel counsel. I would suggest that you use a litigator whom you know and trust, rather than just some bloke that got appointed from Hartford, Connecticut. The insurer must consent to your own choice of counsel if you do it that way, but that consent may not unreasonably be withheld. And again, they have an obligation to pay market rates. I had a case where an insurer was perfectly happy to appoint panel counsel on a very large loss at a very low rate. And so under our California insurance code, we have the right to litigate against the insurance company to get the proper rate applied for our own counsel. And that arbitration was a great deal of fun because I'll spare you the fact that they appointed their panel counsel for every one of their insureds, even in their most complex cases. But when they got sued, wow, they knew how to hire counsel. They went for the whitest white shoe firms they could find, Wall Street and Chicago. So gee, why wasn't what's good enough for them good enough for their insureds, to whom they owe an obligation of good faith and fair dealing? That sort of won the day. Consent as to settlement. There are certain policies where a professional is involved, where express consent of the insured is required. There are other policies in the general arena where it's not, but if you're dealing with lawyers or physicians or other degreed professionals, they have to consent before a settlement will be entered. That's because, for example, with doctors, settlements are reportable over some nominal amount of money. And that affects their ongoing malpractice insurance. It affects their reputation. It can trigger professional discipline. So their consent is required, and that's pretty well established. In the general context, if an insured does not consent, depending on the policy and depending on the state, they may be waiving coverage. One doesn't wish to waive coverage. So it has to be a discussion, if that makes any sense. So, the insurance model has changed. I have a slide that talks about the role of private equity in the insurance field. I touched on it earlier when I talked about reinsurance of existing claims. But private equity can often participate in managing risk, and they can also be an investor in managing risk. And so if you're a mid-cap company, $250 to $500 million TNE, tangible net equity, involving private equity in managing your risk can actually help quite a bit. And I know a number of PE firms that have offshore insurance companies in the Caribbean, and they're also chartered in Switzerland as reinsurers. And these are sovereign wealth funds with billions and billions and billions AUM, assets under management. So if you're in a mid-cap situation, that's something to consider. And a lot of us outside lawyers have this knowledge, and I'm happy to take a call from anyone.